Your landlord tells the council you agreed to leave. No letter, no text, just their word. And the council believes them and calls it lawful. If that has happened to you, listen carefully, because a landlord's word is not proof, and in most cases, what they have described is not a lawful eviction at all. Here is what the law in England actually says. The myth is simple. People believe that if a landlord claims their tenant said they were leaving, that settles it. The tenancy is over, the tenant agreed, end of story. And councils sometimes act on exactly that. A single phone call from a landlord saying the tenant told them they were going. That gets treated as fact. It should not be, and here is why. This is the part landlords and even councils get wrong. So pay attention. Ending a tenancy by agreement is called surrender. And surrender is not casual. It is not one person saying they might leave. The law requires clear and unambiguous agreement by both sides that the tenancy is finished now. Think about what that means. You saying you are looking for somewhere else is not surrender. You discussing a possible move is not surrender. Even telling your landlord you intend to leave at some future point is not surrender. Intention to leave one day and agreement that the tenancy has ended today are two completely different things. A landlord cannot collapse one into the other. Surrender is shown by conduct that leaves no doubt. Handing the keys back. Moving your belongings out. Both parties acting as if it is over. If you have kept the keys, stayed in the property, and your possessions are still there, you have not surrendered anything, no matter what the landlord claims you said. And here is the part that surprises people. Even if a surrender did happen, if you are still living there, the landlord still needs a court order to remove you. That brings us to belongings, and this is powerful evidence. If your things are still in the property, that is direct proof you had not given up occupation. People do not leave their lives behind when they have genuinely agreed to move out on a set date. Your possessions sitting in that room are your case, made for you without you saying a word. Now the big one. Even where a tenant genuinely is leaving, the landlord usually cannot just take the property back. For most renters, whether you had an assured short-hold tenancy or an assured tenancy under the rules since May 2026, lawful eviction means a valid notice, a court possession order, and where necessary, a bailiff to enforce it. That comes from the Protection from Eviction Act 1977 and the housing legislation that sits behind it. Changing the locks while you still live there, with none of that in place, is not a shortcut. It can be an unlawful eviction, and that is a criminal offence, not a paperwork slip. A landlord does not get to skip the courts because they have decided in their own head that you agreed to go. Now here's something the police often get wrong. They may turn up and tell you it's just a civil matter, nothing they can do. But that is a mistake. Illegal eviction and harassment of a tenant are criminal offences under the Protection from Eviction Act 1977. And even if the police step back, your council has a Tenancy Relations Officer whose job is to act on exactly this. So if one door says no, knock on the other. Now, one honest exception, so you have the full picture. If you are a lodger who shares living space with your landlord, you are what the law calls an excluded occupier, and you can be asked to leave without a court order. But for most people renting a place of their own, that court process is your protection, and it is the law. So why do councils sometimes wave this through? Because it is faster to accept one account than to test two. But a council has a duty to look at the evidence, not just take the landlord's word. If you disputed leaving, if there was no written notice, if your belongings were still there, those are facts the council is supposed to weigh before calling anything lawful. And here is the sharpest point. If a council has already told a landlord in writing what the correct eviction process is and warned them against harassment, then that council already knows the proper steps. If it later treats a lockout as lawful anyway, it is contradicting its own knowledge. That kind of inconsistency is exactly what can be challenged, including all the way to the local government and social care ombudsman. So if this is happening to you, here is what beats a landlord's word. First, put everything in writing. If you have told them you are not leaving and not surrendering, keep that message. Written evidence outweighs a verbal claim every single time. Second, document your belongings in the property. Photographs, dates, anything that shows you had not moved out. Build the picture that proves you were still in occupation. Third, ask the council, in writing, exactly what evidence they relied on to reach their decision. Make them show their working in detail. A lawful decision can survive that question. A lazy one often cannot. And fourth, get advice early. Shelter, citizens' advice, or a housing solicitor can tell you whether a decision can be reviewed or challenged, and legal aid may be available. Unlawful eviction is something the law takes seriously, even when a council has been slow to. A landlord's word is not the law. Intention to leave is not surrender. And a lockout without a court order is not a lawful eviction, whatever anyone tells you. This is general information, not legal advice, and it applies to England. Know your rights and never get fobbed off.